A program dedicated to truth and justice. Was justice done in the Jack Carroll case? You be the judge. Our guest today is Albany attorney Jim Gross, who was hired by Judge Patrick McGrath's courthouse in Troy to represent Jack Carroll. Was it specifically to write a 440 motion? Was that?
Yes, it was. Yes.
How long ago were you hired?
Oh, I think it's been close to a year now.
Now, you have your own private practice in Albany.
Yes, I do.
And do you do a lot of this independent writing of being hired by a court?
I do. I've done a fair number of post-conviction motions, which are referred to in New York's law as CPL 440 motions, and I've done quite a number of those at this point.
Now, a 440 motion is different from an appeal. Would you explain that?
Yes. After a person is convicted at trial, they have an opportunity to have that conviction reviewed by an appellate court. This would be a higher court that stands above the trial court. With regard to a county court, as in the case of Mr. Carroll, he was convicted in the county court, Judge McGrath's county court in Rensselaer. An appeal from that decision goes up to the 3rd Department of the Appellate Division, the Supreme Court's appeal court.
And what kind of a court is that?
That's the Supreme Court's appeal court. It's the appeal court that stands above the county court and reviews on a properly filed appeal what the county court did. And that's a state court. The state Supreme Court has what's called an appellate division, and they're divided among the state. In Albany, in Rensselaer, appeals go to the 3rd Department of the Appellate Division.
That's an appeal, right?
That's right.
Then it would go from there up to the Court of Appeals.
In the New York State Court of Appeals, that's correct.
Now how is that different from a 440 motion?
A 440 motion can come either before or after an appeal has been completed, and the 440 motion goes to the original trial court generally, which in this case would be Judge McGrath. And Judge McGrath has an opportunity to review what happened or didn't happen at the trial and make a determination of whether that conviction should stand or whether perhaps a hearing should be held to determine whether it should stand.
Now, has there already been an appeal in Jack Carroll's conviction?
There's been 2 appeals to the 3rd Department. Mr. Carroll had a trial originally before Judge Size. He was convicted at that trial. An appeal went up to the 3rd Department. The 3rd Department changed his sentence somewhat, but really didn't alter the outcome of that trial. That decision from the 3rd Department was then appealed to the Court of Appeals, the New York State Court of Appeals. And the New York State Court of Appeals threw out Mr. Carroll's original conviction, and he was granted a new trial.
And in that throwing out of that conviction, they said there was. Can you describe why it was thrown out?
The original trial contained a number of different charges against Mr. Carroll, all involving or allegedly involving his stepdaughter. Among those charges were 4 rape charges, which required a showing that the victim or alleged victim had been penetrated. The Court of Appeals found that there had been no evidence of penetration, and certainly no evidence beyond a reasonable doubt that there had been penetration. They therefore threw out the 4 rape charges.
Was it also based on the tape?
Yes.
That was apparently the police called. They set up a telephone call with the stepdaughter to Jack Carroll, and recorded this conversation in which he vehemently denied having molested his stepdaughter.
That's right.
And the district attorney or the prosecutor did everything she could. She apparently felt that was exculpatory, that it made him look innocent. And she worked very hard to keep that out of the first trial, right?
That's my understanding. Now, the 4 rape charges were thrown out on the issue of penetration. The remaining charges they ordered a new trial on the basis that the prosecutor had argued throughout the trial that Mr. Carroll never denied this. And all the time she was arguing that he had never denied it, there was a tape sitting there in which he denied it over and over again. And that tape had not been allowed into evidence.
Why can't we say then that she lied to the jury? Everyone seems reluctant to say that the prosecutor lied. In her summation, I understand she said he never denied it. The police officers on the stand said he never denied it. And yet that wasn't true.
Well, the police and I think to a certain extent the DA came to the conclusion through their interpretation of this tape that somehow Mr. Carroll's denials were in fact admissions. And the police actually testified in that manner during that trial. And they said that the way he denied it, or his body movements, or you know, the way he crossed his arms or uncrossed his arms and shifted in his chair, this kind of thing, somehow in their minds amounted to a confession, even though his words were those of denial.
And that was her argument in the second trial, right?
Yes, that was continued into the second trial.
Okay, so the 440 motion now is different in what respect?
Well, the 440 motion that we have brought on behalf of Mr. Carroll is based in large part on a decision which was handed down after Mr. Carroll had completed his appeals.
That's the Lewandowski case, right?
That would be the Lewandowski case.
And what happened in that case?
In that case, the Third Department, the Appellate Division of the Supreme Court, looked at a conviction of a man by the name of Lewandowski who had been convicted of sexual crimes. And they determined that that trial was so unfair, the conduct of the DA was such that that conviction could not stand, and they threw that conviction out.
So it never got up to the court, the Lewandowski never got up to the Court of Appeals?
That's correct. That's correct. It was thrown out by the Third Department before it got to the Court of Appeals.
Now, in your 440 motion, you claim that by doing that, the Appellate Division was in fact writing new law. Is that the way you put it?
Yes, yes. You know, that's going to be, I'm sure, part of the argument that goes in front of Judge McGrath as to whether Lewandowski really is new law or whether it's a further explication of old law. But in our view, the Lewandowski case was tried by the same DA in Rensselaer County, and she did many of the same things she did in the Lewandowski case, she did in the Carroll case. And what made the Lewandowski case unfair, made that trial unfair, took place as well in the Carroll case. And our argument is that that if it was unfair in Lewandowski, it's unfair in Carroll, and that case ought to be, the Carroll case ought to be thrown out as well.
And isn't the big issue prosecutorial misbehavior on the part of the prosecutor? It
is.
And now, in your 440 motion, you detail various instances of prosecutorial misbehavior on the part of Patricia DeAngelis, who in both Jack Carroll trials was the assistant DA, but she was the prosecutor. Now she is the DA. Can you go over some of those detailed instances?
Yes. The major concerns, or a couple of the major concerns with regard to the way that the DA handled the Carroll case are that, one, she continually interjected her personal opinions about the defense witnesses and the prosecution witnesses. So rather than simply putting forward the evidence in front of the jury and allowing the jury to make a decision about these witnesses, she tried to use her own personal credibility to either rise up the prosecution witnesses or tear down the defense witnesses. And if you look through the trial and the trial transcript, you'll see that she constantly used the phrase I. I believe this witness, I don't believe this witness. you know, I put this witness in front of you because...
I know she used the term, as far as that's concerned, when I look at that or when I think about that, I want to puke. She used that term, right?
Right, right. I believe that particular phrase was in the Lewandowski trial. At one point she said in the Carroll trial, she was commenting on the fact that the defense had raised the issue that Mr. Carroll's estranged wife,
that's Paula, right?
Paula, had wanted him back, and she said something like, well, he's not a great prize. You know, and again, she's using her personal opinions to try to sway the jury, as opposed to using the facts that are in front of the jury to try to persuade them.
Now, she apparently did this in both Jack Carroll trials, and both judges let her get away with it. Why is that? Or don't they have complete option to crack down on a prosecutor?
Well, to a certain extent, they do. The court of its own initiative can stop a prosecutor from doing certain things. Generally, a court will rely on the adversarial system and wait for the defense lawyer to object to certain things. That puts the defense lawyer in an awkward position, because the defense lawyer doesn't want to be in a position of appearing to the jury to be trying to hide things and of trying to silence the prosecutor. And so a defense lawyer will always be reticent and careful about objecting too much, because then he or she starts to look like they've got something to hide. So it puts the defense lawyer in a bad position. And you know, to the trial judges, in the trial judge's defense, the Lewandowski opinion didn't come down until after the Carroll case was well over. And in that decision, the third department went through a list of things that they found objectionable. And even though in certain cases the trial judge had said, had stopped the prosecutor from doing it or had told the jury that was improper, they said that the cumulative effect of these errors, this misconduct, was to deprive Mr. Lewandowski of a fair trial. So I think it's fair to say that until the Lewandowski opinion, no one had put together kind of a list of errors and how those errors could affect a trial. And our position now with this 440 motion is that that list is out there now, and the third department has spoken. They've said that this particular prosecutor can't get away with these specific things. And now we're asking Judge McGrath to look at what happened in this trial again and make a determination as to how close it was to the Lewandowski opinion and whether or not Jack Carroll got a fair trial.
Can you think of any other issues in this 440 motion that happened in the trial?
Well,
I know she called several witnesses liars.
Mm-hmm.
She called Jack Carroll's mother, Phyllis, a liar. She called any number of witnesses liars, and that's inappropriate. And again, you would think that that was such an obvious transgression that she would have been corrected.
Well, I think that's a fair observation to make. Again, in defense of the judge and of the defense lawyer, there's a lot of things that happen in a trial. It's often hard to put them all together and have a feeling for really what's going on in that trial until you have a chance to look back at it and see what happened. Some of those things that she said were objected to, and some of those objections were sustained by the judge. But there was really just a continuous barrage of objectionable statements on behalf of the DA.
Can you think of any others?
Well, I think at one point she said that she made some argument, and she said, "I'd like to see Jack Carroll weasel his way out of this." I mean, first of all, weasel is not an appropriate word to be using. in the context of a trial. It's not an appropriate word for a DA to be using. And it shifts the burden, which is another thing that the Third Department pointed out in the Lewandowski opinion. If when a defendant